Hey everybody, welcome back to the show. This delayed broadcast of our weekly podcast. That's my fault. I was away last week. My name is Patrick Tan, General Counsel for ChainArgos. As usual with me every week, and this week will be a double episode. Today's Monday when we're filming this. Jonathan Reiter, our CEO and Chief Data Scientist, is with us, and we're going to talk about stuff that happened last week when I was away. So that's on me. So we're going to talk about the Hong Kong licenses and a whole bunch of virtual asset service providers, VASPs for short, who've withdrawn their applications. A little bit more background and information on that. We'll talk about SAB 121, which got vetoed by the Biden administration. For those of you who don't know what SAB 121 is, again, we'll explain that when we come to that topic. Finally, Custodia Bank has been making a lot of noise about how the system is, as they imply, perhaps, I don't want to use the word corrupt. What's a better word for that?
When there are implications that there is bad stuff going on.
That's not a bad way to put it. Yeah, bad stuff going on is generally how...
Unfair bad
stuff that has to do with people knowing other people. Yeah, so... And we'll talk a little bit about that towards the end of the show. So let's just talk about the Hong Kong VSP licenses. I've seen quite a bit of this, and I want to talk about that, John. I've seen quite a bit of hue and cry, so to speak, on various social media platforms. But maybe you can give us a little bit of background about the Hong Kong licensing regime and what's going on.
Sure. So Hong Kong announced months ago, 4 months ago, 5 months ago.
Some time ago, actually. I feel that, yeah.
Beginning June 1st, you would only be allowed to operate in Hong Kong if you had a license or a license in the pending application process.
And when you mean operate, you mean basically operate any kind of virtual asset service provider, like any kind of thing to do tokens?
Yeah, as I recall, the statement wasn't one of these 20-page long, extremely carefully written. It was just that you can't do any crypto stuff in Hong Kong. Like, the ability to operate that you've had for a long time, when the rules were a little bit unclear, and maybe this is or wasn't a service that was regulated, whatever, all that was finished as of June 1st. You need to be prepared to explain how everything you're doing is not relevant or related to this area at all.
Okay.
It was a reasonably clear statement. And initially it seemed like they were just saying, look, you've had a long time to submit applications, and that's fine, and you need to get with it. Right, either submit an application or leave, which is at some point very reasonable. Now, the interesting little follow-on here is that a whole bunch of firms withdrew their applications very recently.
Yes.
Because, and this is, I don't believe we have an official government statement to this effect, but a lot of statements, people saying they were told this and withdrew their application. They needed to promise not to have any mainland Chinese customers out of Hong Kong or out of any other part of their company, conglomerate, whatever. So, we talk about Binance a lot, or OKX, or whatever. They operate in lots of countries, and they weren't saying the Hong Kong branch can't have any Chinese customers. They were apparently saying you can't have mainland Chinese customers in any of your places.
Yeah.
Which, first of all, is a clear statement, I suppose. Now, I don't know if we got down to the level of can you have a PRC citizen customer resident in Western Europe?
Yeah.
But I mean, clearly what they were talking about were people who were in China who access stuff externally, VPN, whatever, this type of an arrangement. Okay. So that, and almost everybody withdrew their applications at that point. The first thing, of course, is to say that makes it extremely clear how important the Chinese market is to these folks.
Yeah.
People can say whatever they want about what markets they do or don't service, care about, want to service, whatever it is. But if somebody says, leave our country or promise to never interact with that market, and they leave your country, it's because, or your regulatory jurisdiction, whatever. That's important, as we'll come to in a second. That means that other market's more important than those licenses. To some extent, this is a little bit strange in that, if the U.S. said you can't have any customers in France, they're entitled to say that. France can say you can't have any customers in Ecuador.
Well, I guess you could look at the sanctions, right? Because the U.S. does say you can't have any customers from Iran, for instance.
Yeah. Countries make statements like that before, and, financial regulation is a lot of discretion. This will be a theme of this week's podcast. Similarly, Hong Kong and China are, in a very formal legal sense, the same country. So saying this part of the People's Republic of China jurisdiction doesn't allow you to have customers from that part because the rules there, don't permit it. Yeah, that's not really nuts at all. That's far more reasonable even than sanctions. The thing about sanctions is one country says this other country over here, we don't like that. Here they're saying, we're sort of sibling countries in some sense. They're within some bigger system.
I think we can't use the word countries because Hong Kong belongs to China. And,
yeah, whatever. They're sibling legal jurisdictions.
Yeah.
With one thing above them.
Yeah.
And fair enough. Like this guy, okay. That's not crazy.
Just to help people understand this would be like the equivalent of saying that the state in the state of Wyoming, murder is legal, but only the state of Wyoming, and that is in. But you can't murder anybody else in the rest.
Okay.
Yeah,
I wouldn't go equating the U.S. Constitution full faith and credit clause to the way the different systems within the PRC work. They're very different. They're very different. Yeah, but they're related in some kind of a way.
Well, if you just look at it from a practical standpoint, what would make anybody think that if China has outlawed crypto for its citizens, that they would create a loophole where Hong Kong could service the mainland? That's nuts. I mean, if you look at it, there are plenty of places where I think Vietnam is one of those places where you have casinos in the country, but locals aren't allowed to go in at all. It's not like in Singapore where you can actually pay a fee or something, but in those countries it's a strict no. If you're to check your passport, you have a local passport, there's just no way you can get in to those casinos. So I'm not sure what was so surprising. I guess for those people who had tried to apply for these licenses, I think the thinking was that it would be good if we could service the Chinese markets and have a Hong Kong license.
Presumably out of the Caribbean, Seychelles, whatever entity.
Well, if you ask me, this will just mean that they'll just go back to business as usual, which is just to use offshore entities and encourage a whole bunch of Chinese to use VPNs.
Well, they are very clearly cracking down on the usage of crypto by these OTC trading desks in Hong Kong that have always been subject to and followed very few rules. We're not saying they're actually doing things that are illegal, just there were not a lot of rules. There was regulatory clarity, which was, don't make us angry about some unrelated crime that was facilitated by your payments. Yeah, and that's starting to get cut down. So I don't think they'll go back to business as usual. I think they're going to have to find a way to do this stuff without access to that much of the Hong Kong ecosystem.
Sorry, when I meant a business as usual is to bring everything offshore, because for a while I think some VASPs in Hong Kong could get bank accounts.
But it remains unclear how workable a lot of that business is if the crypto for cash OTC business in Hong Kong is itself significantly curtailed.
Yeah.
That was certainly a meaningful, if not essential, part of this whole process, and we'll find out. It was friend of the podcast, DMT Capital, I believe, tweeted out some photos from some of these OTC desks quite a while ago. I mean, people do volume. Yeah, so it's clearly not just a small size retail thing.
Yeah, I mean, it'd be interesting to see where it goes, but I'm assuming it will go somewhere. It's hard to say where.
I don't believe these regulatory decisions are appealable in any sense.
No. Yeah,
and anyway, it's the Hong Kong government saying, we'd like you to follow mainland Chinese law. They're not appealing that. Like, they're entitled to have that opinion.
It's not even
ahead.
an opinion.
Right?
It's not even an opinion.
That's fine.
Those are the rules.
Yeah.
All right, let's talk about SAB 121. What is SAB 121 for the viewers who don't know what that is, or the listeners who don't know what that is?
So this was a SEC staff accounting bulletin from a couple of years ago now that essentially said if you're a financial services business in the United States and you have crypto assets that you hold for customers, you still need to hold them on your balance sheet for regulatory capital calculation purposes.
Yep.
The effective result of this accounting rule suggestion, it's not a law, it's a regulation, but sort of vaguely carries the force of law. The effective result of this was that banks and other highly regulated financials in the U.S. couldn't really provide custody services for, by dollars, it's Bitcoin, right? Bitcoin, Ether, because they'd be required to hold reg cap for custodied assets, and traditionally custodied assets you don't have to hold reg cap against. You may need to purchase insurance or something or have certain procedures set up. We'll come to this in a second, but it's usually an awful lot less expensive. In bank reg cap for 100% of the amount of crypto was now required because the capital requirements for on-balance sheet crypto are effectively 100%. So that would mean that for every dollar in crypto I held in custody, dollars worth of crypto held in custody, I'd have to hold $1 in equity, in balance sheet equity capital, and that would cost me whatever my cost of capital is. So that's 5%, 10%, 12% type per year, which is very, very expensive, and you cannot charge cost of equity capital type amounts for crypto custody. No one will pay 5% for custody. That's 100 times too large, 50 times too large, 10 times too large. It's way too large, way too large. So this was a long-running debate back and forth, and people were happy about this, unhappy about this. We'll discuss the substance in a moment. So the Congress in the U.S. passed a law saying this is not supposed to be the rule. It's a regulation. So the SEC they used their discretion to interpret things and told companies this is how they were supposed to behave. And Congress came back and said, that isn't what we said and or what we meant. And so what we mean is for this rule to not be in place. Passed a law. The Congress is entitled to do that. The SEC interprets rules, laws, issues rules, whatever. It doesn't issue laws, it issues rules. It issues interpretations of laws. And Congress can decide that they did it wrong. That's part of the system. That's totally fine. However, the U.S. political system, various parties have to agree for something to become law. And in this case, the president vetoed it. Fine. So it's not law. Passed by parts of the government, rejected by other parts. Everybody has to agree. We're not going into the whole process of how the U.S. government works. So this rule is still on the books, such as it is. Whether someday somebody will be able to complain in some kind of a regulatory proceeding that they interpreted it differently and they had latitude to interpret it differently because the government couldn't decide itself what the rule is. Maybe there's a case there. I don't know. People normally just hold the required reg cap and move on, but whatever. What I find interesting here is that there was an incident just last week that makes clear why the SEC felt that way in the first place.
Yeah.
So in the original publications discussing and issuing this guidance, they'd said that one of the concerns is that a lot of cryptography that's required for digital assets, irreversible transfers. If there's thefts, you may never be able to get the money back. It may not be possible to have the usual sorts of safeguards. If you break into a broker and you steal a bunch of stock and transfer it somewhere else, the depository can just freeze them and transfer them back. Right? If you steal money from a bank online and you don't cash it out, they'll be able to get the money back from you. Everybody knows this. This is a thing. Payments get reversed. Fine. The details of that are unimportant here. The SEC said specifically that was one of their motivations in requiring 100% equity capital to be held, 100% reg cap to be held. A Japanese exchange was hacked for $300 million worth of Bitcoin last week, and they are going to make it up out of their own coffers. Right? They're just paying it back because money was stolen, the Bitcoin were stolen, and they don't know how to get them back. I presume they will pursue to try to find it and whatever recovery services, but they may never be able to get the Bitcoin back. We see this fairly often where there's a hack, and this is particularly the case with Bitcoin and ETH. Stablecoins are much more complicated, and nobody will take the coins, but they're still sitting there. They're not recovered. Right? You can't seize them, but you also can't spend them. So the money's just kind of off in the ether, which may make you feel a little bit better as a victim, but you still didn't get your money back. In this case, the parent company has a huge amount of money because they're involved in, they have a Forex brokerage, they are a large porn producer, they do all kinds of stuff in Japan.
It's a diversified conglomerate.
It is definitely a diversified conglomerate. They used to be based out of the office building I worked out of very, very long ago, so that's how I know these people. Or know of these people. I don't know this guy. But yeah, they can pay it, and I'm sure he doesn't want any regulatory problems, so fair enough. And in this case, the 100% capital was required because they needed to pay it out.
Yeah.
Right? I'm not saying that'll happen every time. Maybe you could have bought insurance, you could have done things differently, whatever. But it doesn't take, and this is a regulated financial services business in Japan. They run a reasonably large FX trading platform. They have other financial services products. They've been around for decades. This is not two dudes in a rented office trying to figure out what the rules are and get some clarity. These are a large, well-funded, well-organized, extremely well-lawyered up conglomerate. Yeah, it didn't go well for them. I'm not saying it's their fault. What happened.
I mean, if nothing else, I think it. Well, not. I mean, obviously the hack is unfortunate, but I would say it did go well for them because their customers were made whole.
Well, it's okay for the customers. This guy's out $350 million.
Oh, I mean,
so it's not going to take a lot of those for regulators to say, yeah, this looks justified. Because the last thing they want is for you to have 30% equity held against it, and for your customers to then be out 80% because you relaxed the rule. Okay, this is not going to happen all the time, and it's probably conservative most of the time. You're never going to lose more than 100% of the money, right? So it's never going to be not enough, right? Yeah, it is an interesting situation. It seems like that's pretty good ammunition for the people pushing for extremely high capital requirements for banks, because if the transfers are irreversible, their normal tools are just not available.
Yeah, I think that's it's not going to be a popular opinion amongst the crypto bros, but I think that's reasonable, actually.
I mean, the JFSA tends to look into incidents in excruciating detail. Anyone that's done business in Japan will know that if there's a problem, it is investigated to a painful level of micro detail. So this will likely be well documented somewhere, particularly because I don't think the rest of the financial services industry in Japan is a huge fan of this guy. So they'll probably try to make it look like it was a little bit their fault. Whether or not it was, we have no clue what happened with this hack. So you'll have some interesting documentary evidence there. I mean, maybe you cut it to 50%, but you're not going to cut it to 2% if 100% is at risk.
Oh, yeah, no. Okay, on that note, let's go to Custodia Bank. And we know that they've made a bit of a hue and cry because of somebody else that was granted, was it Fed Master
Account?
Master Account.
So Custodia Bank was trying to be a bank that will just hold government bonds, cash, insured deposits, whatever, in reserve against issuing stablecoins. Doesn't really want to do anything beyond that. And they've been applying to get a Federal Reserve Master Account, which is the thing that lets you settle with other banks as a large real bank. Otherwise, you're just a company that has a corporate bank account, and people have to pay in and out of your corporate bank account. That's functionally how this works. That's not quite legally the case. They were rejected, and the Fed specifically said they were concerned about, among other things, the idea that they were going to be issuing stablecoins on permissionless platforms that could be traded in large amounts among unknown people. Whether or not you think that's a problem, that is what the government told you their concern was. Fine. So their application was rejected, and they went through some process, whatever, and eventually ended up suing in federal court and asking a court to compel the Federal Reserve, I believe it's the Kansas City Federal Reserve, to approve these people and give them a master account. And the court decision was, we're sorry you got rejected, but the law clearly allows them to reject you, and the reasons they gave aren't ridiculous, so you're rejected. The reasoning, the Fed's reasoning that the court said was not crazy. Custodia Bank is a state-chartered bank that doesn't have a meaningfully powerful prudential regulator, supervisor of any sort, so it's not a federal regulated bank. It's not a thing regulated by stuff in Washington, D.C. Institutions people have probably heard of. Their only regulators are financial services oversight in the state of Wyoming. I'm not insulting the state of Wyoming, but there's no, this is not a large regulatory apparatus. And the rules are essentially your financial statements have to say that you're solvent. We can check in on you a little bit from time to time. That's it, right? And no deposit insurance of any sort.
Yeah.
Right? So the Fed made very clear in their reasoning, because your state charter don't have any kind of regulatory oversight and don't have any insurance for your deposits, you're in the lowest tier as far as assessment is concerned. And for the lowest tier, we undertake the most intensive analysis, and our analysis, and you can get these filings, gave lots of reasons they thought this was a bad idea. And the court said, fair enough.
So think about these administrative appeals. Depending on which jurisdiction you come from, but quite often public bodies, administrative functions, administrative decisions can be appealed in court or contested in court. But usually the court is reluctant to veto or to overturn an administrative decision, especially where it's within the jurisdiction of that administrative body to make those decisions, and two, if it's not arbitrary or there was no reasons to believe that those decisions were made with no basis or on some kind of bias. Or there are very, very few reasons why a court would intervene with an administrative decision. In this case, it's just simply not that. There was just tons of reasons.
The categorization for tiering for risk, for level of analysis, is a very simple binary set of questions, right?
Yeah.
do you have deposit insurance?
Yeah.
And then that's fine, and the government, there's no discretion really there. They're just saying you get the heaviest.
This is the checklist, and well, I mean, it's like if you drive your vehicle into the motor bureau and you have to get it inspected if it has no wheels and stuff like that. That's it.
You have to have brake lights and These are very simple yes/no questions. Now, the Fed was exercising discretion once they had to look at the circumstance of the application, right? But I suspect the court, and Custodia is appealing this, the court is going to say if they can reject anybody, they can reject people that fall into the lowest tier on their own pre-existing scoring system. Try again. Now, Patrick alluded to earlier, Custodia has also made comments about how a bank in Connecticut was previously called Currency Reserve Bank and is now called Numisma, I think.
I don't recall.
Not Burisma, that's different, but Numisma. How they got a Fed Master account because one of their founder, board member, whatever executives was a former Fed vice chair.
They seem to be alluding to the fact that the only reason that they may have gotten that license is because
Okay,
that's what they seem
mentioned
to be
that they were approved, and then in the next sentence that one of the leaders had been a former Fed vice. Is a former Fed vice chair.
I'm not saying that they're saying that that's the reason.
The business of that business could not be more different. So their business line is providing physical cash services to businesses inside and primarily outside the United States. So, okay, that is a totally different set of questions and problems. But what they want is a master account so banks can pay them and they can ship them cash. Obviously, U.S. cash is a thing in various parts of the world. Okay, I have no idea how the logistics of any of that work. I'm sure there's security involved and whatever. But you're talking about transacting exclusively with banks in banknotes bought from the Fed, the Mint, whoever sells the banknotes that these guys would be buying. Those don't seem similar to me, and it definitely feels like a former Fed vice chair would know how to fill those forms out correctly and may well have spotted a business opportunity in the provision of physical U.S. banknotes overseas. I don't know anything about that business, but that looks nothing like providing anonymous transfer stablecoins. Some people may say, well, cash is anonymous. Yes, cash is anonymous, but they're giving it only to licensed banks who are then going to follow whatever the rules are in their part of the world. That's not really the same. Cash is in some sense similar to whatever stable coins, but they're not exactly the same. Nobody's going to argue that. And also, it seems like those people would more likely have organized all their procedures in advance as opposed to just railing against this over and over for a long time as unfair. I mean, maybe it's unfair, but I can understand why the U.S. government isn't involved in the business of selling banknotes to overseas banks, and somebody might step in and say, I think I can do that better. Fair enough.
So basically what we're saying is that, it's important to read behind the headlines and just have an understanding, because I wasn't a big fan of the fact that there was alluding to the fact that, because somebody's a former, vice chair of the Fed and stuff like that, therefore they got preferential treatment getting licensed and stuff like that.
That doesn't mean nothing bad happened here. We don't know anything about this particular case. But these people are pursuing completely different business objectives.
Yeah.
And as every report noted, new master accounts, particularly for non-traditional nationally regulated banks, are very rare. There are not a lot of business opportunities left in that space people want to undertake in novel ways. And, one of these people found one, and one of these people may or may not.
And certainly issuing stablecoins on permissionless networks is not one of the novel business cases which would be so compelling as to justify, the approval of a Fed master account.
Yeah, and no one does that today.
Yeah.
Right? Whereas plenty of people sell banknotes to banks outside the United States. I mean, I assume banks do this with each other. So I'm sure these guys can copy the existing procedures and demonstrate we're doing this the same way XYZ business that does this already does it.
Also, I think just purely from a supervisory perspective, it'd be easier to monitor that business.
All your counterparties are banks. Yeah.
As opposed to stablecoins on a permissionless network.
All your counterparties are people you KYC'd, which is not the same thing.
Which is, and once you go into permissionless, who's using the stable? I don't know. Who's transacting it? That can't be the response to somebody who has a Fed master account.
The cash is permissionless, but of course, essentially everywhere in the world has reporting requirements for cash in various ways.
Yeah, once you
they don't exist for stablecoins.
Once you cross a certain threshold in terms of cash transactions, you have to fill out a form. So, I don't know how you would do that on a permissionless network. Where would you start? Where would the form be?
Fair enough.
You know. So on that note, thank you guys for tuning in. We'll come back Friday with another episode for this week. So we'll see you guys then. Bye bye.